And it's my great pleasure to introduce our long-standing friend and contributor to faculty events for this week. Michael is going to give his paper this evening. It's been a great pleasure already to have Michael and Heidi with us, and we're delighted that we're continuing this evening and tomorrow evening as well. I remember on another occasion when I was sitting here having to introduce an eminent colleague, and for some time I was thinking, what can I say about this guy? I mean, whatever you say seems trite compared to what is done, and you either spend half an hour talking about all the things he's done, or spend 30 seconds and miss out 90% of them. So, in the end, I just said, this is a person who likes scaling the heights of our subjects, climbing mountains, but to extend the metaphor, he will take a photograph of every tree on the way. With Michael, not having had the pleasure of going tree hunting with him and a camera, I had to rely on another colleague whom I greatly respect, and is greatly respected within our community of legal theorists, legal philosophers, whatever you want to call this. And I mentioned that Michael was coming to us and was going to engage with us here in Singapore. And he's a very well-mannered man. He doesn't exaggerate, and he doesn't make an effort to say things for effect. He just came straight out. In my opinion, this guy's the biggest hitter we had at the time. So, hit it.
I don't know, I should protect myself and say little. Anything else? Well, we have to stop meeting like this, Andrew. We did this a year or so ago in Bucharest. That was good fun. Really a great pleasure to be here. I feel very at home in places like this, Centers for Legal Theory. Heidi and I have founded 5 of them around the world. We're kind of Johnny Appice into these things. But they all feel very much at home. I've been giving these kinds of talks for over 50 years. I enjoy it just as much now as I did when I started, but one of the nice things is the audience is much more receptive to legal theory and better trained, as is this group. Good discussions and good friends. It's really nice. So, pleasure to be here. Never been to this university before. I was here in Singapore 40 years ago, but hardly remember it. It doesn't look at all the same. Every tree, huh? Every tree on the way up. Yeah, that's probably true, but it's shorter than hers was. And I did have an outline, I don't know, that you could pass around of the whole thing in case you want to see the whole argument. But I'm only giving a piece of one chapter of the same book from which Heidi's presentation was drawn on Monday. Namely, it has to do with liberty. My topic is the general right to liberty. And I think the title was The Renewed Importance. Renewed because of the setting in which the political philosophy about the nature of liberty has become quite salient in the United States, namely with the ruling last year of the abortion decision Roe versus Wade. It's thrown into jeopardy of 50 years of our Supreme Court and federal court precedent with regard to protection of liberty under the substantive due process clause in the U.S. Constitution. So the chapters of the book in which this particular question is raised is a set of chapters having to do with constitutional law. I go through what's not in the assigned readings. I did include them in the readings of Andrew's and James' suggestion, are questions about the legitimacy of courts rather than legislatures deciding what the contours are of the right to liberty, the determinacy of the language of constitutions as to whether you can extract from them in a meaningfully constrained way the nature of liberty, the administrability, particularly in the parochial concerns of U.S. constitutional law, whether you could take a natural right to liberty and use it in the way the Supreme Court has. But the fourth of those concerns, which is the bulk, which is the burden of this chapter, is a fourth kind of criticism that social conservatives in America have been making for quite a while, which is there really isn't an underlying right to liberty. Conservatives in America, to the extent they aren't the people you see on television scrambling around the House of Representatives these days, that is, that they actually think there's two kinds. There's social conservatives and libertarians, so they're very different. And the social conservatives, following Hipp and Burke, think that the right to liberty of Rousseau would lock all of those like it. Make no sense because it leads to anarchy. There's no limits to the liberty. So the skepticism here is there's no underlying political right or natural right, moral right to liberty on which constitutional right could be founded. So I left aside the legal concerns about determinacy of text, legitimacy of court function, and administrability of a constitutional right for just this criticism. Is there an underlying moral right to liberty that has contours sufficiently definite that it could be used to ground a constitutional right in America or in any place where courts are judicial review? That's really the question. So you can see the project is bounded with larger concerns. It does come from a book with even larger concerns. As we're up to 22 chapters, it puts this one. There is a piece of the book that you need to get this project started. It's in chapter 1, which I did not include. Basically, so 5 things quickly that we presuppose in this part of the book, but we do argue for in chapter 1. One, we are now Monroes who think that morality is a matter of convention. We actually think there's an objective moral reality, which we've argued for in various papers for a long time. Secondly, that the nature of that reality is such as a matter of substantive ethics, that at least part of it is deontological, and at least part of that is rights-based, that there are such things as natural rights, moral rights, rights older than, as Douglas put it among his opinions in the U.S. Supreme Court, older than our Bill of Rights, older than the legal rights that were based upon. Thirdly, if you're going to talk about right to liberty, you do need to get clear what you're talking about. Liberty is an open-ended term that's both ambiguous and vague when used outside of a particular context. Isaiah Berlin purports in his concepts of liberty to isolate 200 some-odd senses. It's not quite as ambiguous as that. You do need to say what it is you're after. This book is about, this part of the book is about negative liberty, freedom from constraint. Not the positive liberty, not the liberty of the moderns or the ancients versus the ancients. It's really negative liberty, absence of constraint. The vagueness, once you've disambiguated it, as the linguists say, to precisify it out of its vagueness is to make precise exactly what kind of restraint it is, the absence of which is the essence of negative liberty. That restraint in the case of political philosophy is the restraint of those legal sanctions that don't price behavior but forbid it. And that's criminal law. So the liberty we specifically want to focus on is the liberty that is the freedom from the criminal sanction. And the question is whether the state should observe the limits that that liberty demands in its legislation of what should be made criminal. That's the nature of the liberty that we have in life. We'd also, in that early chapter, do something which is presupposed here. It's something what Heidi did on Monday, but it was very abbreviated, which is to discuss why negative liberty is of value. You notice one of you, I said, thought it was an intrinsic value on Monday. Many of us think that's true. Many of us also think it's an instrumental value. It's useful for positive liberty, for million autonomy, for Kangian autonomy, which was different. It's useful because people often prefer. There aren't any happy slaves, preferring free and so forth. The set values to which it's instrumental, and it's a case that can be made. Importantly, the case made in general is a case for what Joel Feinberg, the political philosopher of a generation ago, called the presumption in favor of liberty. It gives you a presumption that citizens ought to be free of criminal coercion unless the state has a good reason to coerce them. But it's only a presumption. That's different than a right to liberty. So you may remember Kane's discussion on Tuesday in his paper of the evolution as he charted it through intellectual history, of the difference between a state of affairs being right and someone having a right to that state of affairs. A right to liberty is the second of that pair. It's not just that there's value, even a value that is maximized vis-a-vis any other values that make it right. It is that someone has a right, and thus saying that liberty is valuable is not yet to say that people have a right to liberty. That, at least, is the inquiry set for this chapter, which is there a moral right to liberty, on which the later chapters can then ask, on which the constitutional right to liberty can be built. So the organization goes like this. Two different rights I try to articulate in the chapter. The two different rights correspond pretty precisely to two different objects of moral evaluation. The deonic ethics that we were discussing in Monday, as opposed to the Utilitarian ethics, the deonic ethics typically is thought to concern itself primarily with actions, or in some versions, intentional actions. Intentions and actions are the locus of what it is that our obligations deonically are thought to have as their content. But secondly, at least for some forms of ethics, from Kant to Rawls, they also concern the reasons with which actions are done. As Kant would say, it's not just right reason, it's not just right action, it's right action for the right reason. Kant had a notion about how actions have moral worth only if done out of a certain reason. Those are called positive second-order reasons in Raz. For Kant, it was reverence for the moral law. And then there are the negative second-order reasons that Raz made so famous with exclusionary reasons, namely reasons that you ought not to have, that make it something that is prohibited, not just prohibited to do the action, maybe not prohibited to do the action at all, but prohibited to do it for that reason, the exclusionary reasons of Raz's philosophy. So two things can be evaluated: actions and the reasons for which actions are done. What I call the two rights to liberty correspond to that distinction. One is a right to do certain kinds of actions. This is the proverbial, since from Mill to the U.S. Supreme Court, sphere of liberty. The sphere of action is relatively immune, or perhaps, depending on your view of the forcible right, absolutely immune to state regulation, state coercion. I call that the basic right to liberty. What I will call the derived right, and I'll say something about why it's derived, what I call the derived right to liberty is about the reasons. Citizens have a right not only to immunity of certain kinds of actions being free of state coercion, they also have the right to demand of their legislators that they aim at some things and not others, as they coerce them in their prohibitions of the criminal law. That's a right to have legislation motivated in a certain way, a right to reasons being used, the things at which legislators should aim, of which each citizen has with the correlative right. I call that the derived right to liberty, two very different rights based on this distinction between reasons. So in the case of liberty, you get a sphere of liberty of action, and you also have, if there's a second sort of right, a right that's however actions are prohibited, or whatever actions are prohibited, they were prohibited by legislators aiming at proper rather than improper aims for legislation. I keep these two honestly, because if you start reading Mill, and I read everything since Mill, including U.S. Supreme Court again, you get these two different discussions. One is a discussion about is there good reason for the legislation, and the other is a discussion, is there a strong reason against it? The people who want to know about is there a good reason are often looking at legislative aims, and the people that say there's a reason against it are basing it on a citizen's right of liberty. Two different discussions that are uncomfortably melded together. That means things like Mill's harm principle, classic answer. Is it answer to two different questions, which means it's two different answers. One is an answer of proper legislative aim. This is what the legislature should aim at, Mill said. Only that behavior harmful to others. It's also a definition of a sphere of action immune to state regulation. Namely, the state can't really regulate a behavior that actually is harmful to others with its coercive sanctions of criminal law. Two different discussions to have. They get smushed because the primary audience for political philosophers, on this topic at least, are people who are legislators or who are placing themselves vicariously in the legislative role, asking what laws we ought to have. From a legislative point of view, it's easy not to see the distinction between what should I aim at in my legislation as a matter of subjective motivation and what is a matter of objective reasons justifies the legislation. You will think, of course, if it's proper for me to aim at it, it must be a good reason justifying the legislation. And of course, if it's a bad or improper reason to aim at it, it must not justify the legislation. Perfectly reasonable thing to say. But take it away from a legislator, make it a court reviewing a legislator or a citizen judging how well their elected representative is doing his or her job. And you end up with a distinction that's pretty viable. Namely, one question is, did you get it right? Did you prohibit actions you're entitled to prohibit as a matter of good justifying reasons? The other is, did you aim at the right thing when you were prohibiting whatever it was you were prohibiting, whether you hit the target or not? What were you shooting at? Two different questions. Okay, that's what organizes the two rights to liberty. So, first right, derived right. Why do we call it the derived right? Because it's derivative in a citizen from the more basic duty of legislators to enact legislation for certain reasons rather than others. It's merely the correlative right. It's a right following a duty rather than the other way around. What's basic is the legislative duty. In some things and not others in the coercive legislation, even in democracies. Now you may remember intellectual history, 15 years after On Liberty was published, James Stevens, foremost exponent of the criminal law of England in the 19th century, extremely well known at his time. Now he's mostly known as being the uncle of Virginia Woolf, the novelist, but quite famous in the 19th century. He proposed in his book, was it Liberty, Equality, Fraternity, 1874, that legislators in democracy, it's not that the harm principle was wrong, although I thought that was true too. It's they shouldn't have any principle of that kind. The only job of a legislator in a democracy is to do what his constituents most prefer. You're supposed to represent. And if they most prefer concentration camps, that's what you're supposed to vote for without regard to any judgment yourself about what is right. I've always thought Mill had the better of that one, and namely that democracy is better practiced by having leaders who actually lead. And then if you don't like them, as Teddy Roosevelt said with his bully pulpit image of being a democratic leader, they throw you out. Democracy works by checking you, not by you checking them as to what they want you to do. So that I don't think Stevens makes you get off the boat early. I'm also kind of an E.M. Forster person about democracy. You remember his set of essays, the lead one, which is 2 Cheers for Democracy. 3, Forster said, is out of question. It's only what Churchill said, the best of all systems. We're pretty crappy in all sorts of ways, but all this better than anything else Smith tried. It's just not that important vis-a-vis for other values such as the liberty of your citizens. In any event, this presupposes Stevens is wrong, Mill in this sense is right. Every legislator should have substantive principles guiding the reasons that justify criminal legislation. And the trick is then to articulate those principles. Mill's, of course, was famously in terms of the harm principle. Mill's On Liberty essay, 1850 on, I think has been taken at least, and I think Mill invites it, to make a rather fundamental mistake. It presents itself as giving you a principle, an independent principle of political morality. A principle that guides proper legislative aim and the sphere of action of state regulation. As if it somehow was self-supporting, self-standing, freestanding. Whereas if what you're trying to do is articulate a principle of negative liberty against coercive legislation, you really would do well to look at the reasons why it is the state has coercive legislation called criminal law to start with, to then decide when it should be absent, to know why it should be absent, know why it should be present, right? There's nothing harder. So you first have to ask, what's the right theory of punishment in order to derive a theory of criminal legislation? Now, Mill, of course, is a utilitarian, so the natural question for him would have been, how does the harm principle follow from his general utilitarian theory of punishment? The right question for Kant was, how does your moral wrong theory of what limits legislation, not harms but wrongs, follow from your retributive theory of punishment? So that's what organizes this part of my paper. Namely, alternatively, assume you're a utilitarian or a retributivist, or actually what most people are, the third possibility, usually called some version of a mixed theory that mixes the two together in one mode of combination or another, and then ask yourself, what would the limiting principle be on legislative aim? The things at which a legislature may properly aim in its coercive legislation. Take Mill first. 4 quick questions. What is utilitarian theory of punishment? Everybody knows the answer to that. Bentham said, punishment, of course, is an evil. It's the intentional infliction of suffering and deprivation on a citizen that surely requires justification by producing something that outweighs the evil that is punishment. What is that justification? It prevents crime, is the first and foremost thing that it does. It prevents more crime than the harm that it causes, then punishment's justified. What's the harm principle? Well, for Mill, the harm principle, Jerry Dworkin's article that I edited goes into this in great detail. As he says in the first sentence of that article, it's neither singular nor summit. 2 parts. Harm principle, positive part. Prima facie, regulating behavior harmful to others is legitimate. It is a legitimate thing to aim at, to regulate, to prohibit behavior, because that behavior is harmful to non-consenting others who didn't consent to it. Prima facie, that's positive. The negative one is prima facie, it is illegitimate to aim at anything else. Harm principle is everything harmful, prima facie, can be aimed at to be prohibited, but it's only things that are harmful that can be aimed at to be prohibited, a positive and negative principle. You separate them because the positive is a lot easier to justify for a utilitarian than is the negative. Now, Mill doesn't stop with just, you can't aim at anything else except preventing or punishing behavior harmful to others. He details the other things people typically have said to justify criminal legislation. His animus in particular is directed against paternalistically motivated legislation. Legislation that does not seek to prevent, publish, and punish behavior harmful to others, but only behavior harmful to the self. So the paternalist is someone who says, I know what's good for you. Your behavior is hurting yourself, so I am going to punish you to prevent you from hurting yourself. Paternalism. Second is the offense principle. Behavior doesn't harm anybody, but it just offends them. They don't like to know that it exists or to see it in public. In which event, the offense of somebody else, Mill says, is not a reason that can justify criminal legislation. And the third of those things that are improper reasons is what's often called legal moralism. That a people believes, as Mill says, that a people believes that something is immoral. His example were the Americans before the Civil War, proposing to send a military expedition to Utah to stamp out those damn Mormons for practicing polygamy. Simply on the grounds that even though Utah wasn't part of the United States, by God, you shouldn't have polygamy going anywhere. Mill's example of taking conventional moral belief as a reason to make it crime to stamp out the behavior which by that belief was immoral, usually called legal moralism. How did Mill get from his utilitarian theory of punishment to that rich array of principles going under the name of the harm principle? Well, it's easy to see about the positive part, namely prima facie, to justify the evil that is punishment, as Bentham put it. It is the case that you want to prevent the evil that someone's behavior will cause somebody else. So it may not be, at the end of the day, enough evil prevented to justify the evil of punishment. At least you're in the ballpark. You're aiming at the right thing. So the positive part of Will's principle is pretty good for a utilitarian. Negative parts are much more difficult. So why is it the case that harms to self, for example, can't be the object of a utilitarian justified piece of criminal legislation? Although the behavior is only harmful to yourself, the harm to yourself will be greater than the harm I have to do to you to prevent you from harming yourself. Looks like a perfectly reasonable calculation. Mill's answer in On Liberty is troublesome for the reasons Herbert Hart used to point out in his book Law, Liberty, and Morality in the 70s. Namely, Mill, as he puts it, Hart, makes the gentlemanly assumption pre-Freud that we are each the best judge of what it is that is good for us. You ever watch somebody marry the same bad type of person again and again? You know, it's false. But nonetheless, we are each in general the best judge. It's on epistemic grounds the state should stay its hand, because the individual involved will always know better than the state what actually will harm them or not harm the epistemic argument. With regard to offense, I guess Mill just thought offense was small potatoes. Kind of hard for a preference utilitarian to think that, because offense really makes you prefer that someone not engage in that behavior that offends you. But nonetheless, per se, offense is not a legitimate reason for criminal legislation. The third one I find extremely interesting. So there's a second article by Jerry Orkin, which I edited, which was, what the hell did Mill mean by legal moralism? Did he mean to engage critical morality, or did he simply mean there were erroneous, conventional moral beliefs that could never serve as the justification of criminal legislation? Most liberals take him the first way. They think that Mill means it's never a reason for legislation, criminal legislation, that it's immoral, really immoral. And yet, if you think about it, that can't be what Mill meant by this part of his harm principle. Can't be. Because Mill was utilitarian. The right morality is utilitarian ethics. So if that's the right morality, of course you can aim at immorality as defined by the utilitarians. It has to be so. It has to be his thinking of moral beliefs that aren't utilitarian, which are, for a utilitarian, he's aiming at moral error. I've presented this to a number of Millians, people who write books on Mill, and the best I get out of them is, well, he never at least said that wasn't the case. And I think he has to think this. He has to think that really it's moral error. So then you end up with a Millian principle, which is arguably justified on utilitarian grounds. I think everybody sees the negative part of the principle doesn't easily follow from utilitarians. Every political philosopher I know is always posed to his students. How did Mill get from utilitarianism? Not to the positive part, but to the negative part of the harm principle. I don't think Jack Rawls ever published this, but what he told us when we were his graduate students, we're looking at it this way. What Mill really has is a separate, non-utilitarian value of autonomy. Millian autonomy, not cognate, not acting for the right reason, Millian autonomy. Autonomy which says it's often more important to make a free choice than a right choice. Even if there's a right answer, it's more important that you reach an answer even if it's wrong, than that you get the right answer. So that Millian autonomy becomes a kind of side constraint, and then the question is, how can the utilitarian justify it? Rawls on Mill. The only way a preference utilitarian can justify thinking preference satisfaction is the arbiter of all things moral and legislative, is to think the preferences come from people who form them in ways that are worthy of respect. As Mill himself says in On Liberty, a person whose preferences are dictated by others is no more value than a steam engine. A mere sort of mechanical device can do many things. In that sense, it prefers, of course, behavior to do what it does, but nonetheless, it doesn't have any value because it's not free. So so the condition of autonomous choice is a presupposition of utilitarianism that's different than the usual way people do this, which is kind of an indirect or two-level utilitarianism. But nonetheless, Mill, for one of these reasons or the other, seems to think not only is it an improper reason, but it's improper not just because it's not the right reason, behavior harming others, but because it's independently an insult to liberty to engage in paternalistic, motivated legislation. So, I don't think the offense principles does much better for Mill. My old colleague Joe Feinberg wrote what we used to call the Alexandria Quartet after he got kicked out, after the end of the philosophy program at Rockefeller. He went out to the desert at Tucson. We call it the Tucson Quartet, 4 volumes. for each of these four motivations of nil. All of it called the moral limits of the criminal law, starting out with harm to self, harm to others, harm to self, offense to others, and harmless wrongdoing. 4 volumes. Feinberg is pretty much a million, but even he gets off the million boat on offense, saying if you ever take the ride on his bus of disgust, chapter 1 of Offense to Others, you will probably never agree with Mill again about offense not being a sufficient reason sometimes for criminal legislation. It's just too disgusting. So Feinberg says, I'm half of a million. Most offense isn't enough, but there's no per se rule. That offense itself can't be a sufficient harm for preference utilitarian to justify criminal legislation. Okay, that's the utilitarian. I have to be much more brief on the retributivist. But the retributivist is easy. It's the same thing except substitute the word wrong for the word harm. Namely, the retributivist who thinks the criminal law, retributive theory of punishment, is about giving people what they deserve. So unlike Bentham, punishing people, hurting them with state sanctions, if they deserve it, doesn't need a further consequence to justify because it's intrinsically right that that be done. That's intrinsically good by itself. So the retributivist would then have a moral wrong principle because wrongdoing is needed for there to be retributive desert that would justify punishment. Now, it's a little trickier than that because you might say to yourself, well, why does it need to be prohibited? Why can't you just punish wrongdoing wherever you find it? That's because we're lawyers. We have this thing called legality, rule of law virtues. If you had an advisor in high school like I did, so take Latin if you're going to law school. Nulla puna sine lega, right? No punishment without law. There you are, pay off of years of Latin. The old principle of legality, which says you need to prohibit it, it's not enough that it's morally wrong. It also has to be legally prohibited before you may use the state apparatus to punish. So if you add legality as a side constraint on achieving retributive justice, then you end up with 1/2 of the legal moralist theory of legislation. Legal moralist theory of legislation is you may prohibit all and only behavior that is antecedently morally wrong. That is morally wrong antecedent to its criminal prohibition. That's half of it because it says, well, it's not enough that it's morally wrong. It needs to be prohibited, which means it gives the legislature a prima facie reason to prohibit all things that are morally wrong. Why only things that are morally wrong? Well, here's a second sub-premise that we need to get to legal moralist theory of legislation from a retributive theory of punishment. You have to believe, like Heidi Hurd and Joe Raz and my student Michael Smith, who were called 30 years ago the new anarchists. People who think, unlike Rawls, that the law, even in a just regime, does not even give a prima facie reason of obligation. It doesn't prima facie obligate. Because notice what that does. That means you can't make something immoral that wasn't immoral before simply by criminal prohibition. I'm a new anarchist as well. I think they pretty much carried the day. In which event, as a subsidiary premise, you then get to have criminal punishment of wrongdoing. It has to be antecedently wrong. It can't be made wrong, which is why the legislature not only has a reason to punish all wrongdoing, but it is limited to punish only wrongdoing because it can't make it wrong by itself. Right? That's what gives you legal moralism. It's got some problems too, not least of which have been what you call retributivists. Not everybody is a new anarchist. And it leads to some arguments about, it looks like it's both over and under inclusive. It looks like it includes all moral wrongs. Well, that's why people like Anthony Duff in England, Doug Cusack in America, Joel Feinberg introduced distinctions of, well, there's public versus private wrongs, something like that. I don't do that, I do something else. But you got to say something. And sometimes it looks like it doesn't punish enough because children driving on one side of the road isn't antecedently wrong or right. Yeah, but solution subordination problems, we all have public duties to solve collective action problems, and once that's in place, you now have a duty to drive on whatever side of the road, gosh, you guys rap on the left, whatever side of the road you drive on, it is now your obligation. So you can fit that into, you have to say a lot of things to get this notion of common intuition. That basically is the driver. And the most popular theory of punishment is the mixed theory. But the mixed theory is most restrictive. Namely, it has to be both harmful and wrongful. is the dictate of a mixed theory that says you need two reasons sufficient to punish, which logically means the absence of either is sufficient for there being no punishment. So you end up with the mixed theory leading to what Doug Cusack's law called the wrongful harm principle. The important point for mixed theorists is they're like retributivists. They demand that behavior be wrongful. Unlike retributivists, for them it has to be harmful as well as wrongful, but nonetheless, they share the important characteristics of retributivism. So that's what legislation has to aim at. Now, fortunately for our time, Joel Raz is wrong. Anyway, there is a very tight connection between the kinds of things that will make an action prohibitable rightly and the kinds of things at which a legislature may aim. I won't go into it. In 10 days in London, I was defending my last paper on exclusion. Joe Raz and I had a 40-year debate on this connection between the reasons that properly motivate and the reasons that are good justifying reasons. Raz has this peculiar view that is so peculiar most people misunderstand what he meant by exclusionary reasons. His peculiar view is morality can obligate you not to act for a certain reason R, and yet R remains a good justifying reason. So if by chance, R comes about, he calls that the lucky mistake. You didn't violate your obligation, you didn't act for R, but R came about and made it right. I don't say that's a logical contradiction, it's just a damn peculiar morality. So fortunately for us, we can piggyback the discussion of the right reasons on the motivating reasons that are proper, which is why you end up with virtually the same discussion. Utilitarians with harm principles, retributivists with moral wrong principles. So briefly, in this part of the paper, I said, look, there's three aspects to what in reality is a single right. Call these the three epistemic aspects. One is there are these safe harbors. First safe harbor, where it's easy to say what should be done, is where the legislature is not prohibiting something antecedently morally wrong. On retributivist or mixed theorist grounds, that's a violation of liberty. Irrespective of the reason for which they did it, to prohibit behavior that's not antecedently wrong is not allowed. That gets rid of an awful lot of legislation. It's depending on your view of morality. Mine is morality is totally indifferent to how you practice sex, for example. In which event all of the sexual legislation is irrelevant, illicit. Also true with regard to things like birth control, as the Supreme Court said when it was reviewing the Connecticut birth control statute. I can't think of a reason why Connecticut would do this. It's not wrong to practice birth control, in which event Connecticut has no reason, so liberty swamps the only reason you could have, which you don't have, which is that it's wrong, it's not wrong. In which event, first safe harbor, behavior that's not morally wrong. I and Sandel had a debate in the late 80s with regard to doesn't this make liberalism more honest? Both of us think. It makes it an honest liberalism, he just refuses to call it liberalism. But if you're not a million, if you don't think that somehow morals has to be excluded from deciding what should be prohibited, then the honest liberal engages the conservative on the tournament ground of substantive morality. The dishonest liberal pretends that somehow it's the wrong form of argument for social conservatives to say homosexuality is wrong. It's not the wrong form of argument, it's just the wrong morality, is the Sandel way of putting it. In which event this first safe harbor gets rid of, I think on honest grounds, a lot of legislation I think all liberals oppose. Second safe harbor, what the Supreme Court used to call self-defining choices before the Dobbs decision. What Raz says are the kind of choices that if you don't get to make, you don't get to lead your life. There are some choices about who you marry, how you practice sex, whether you have children, to what God, if any, that you pray, how you're going to die, how you're going to treat your body, where you're going to work, how you're going to raise your kids. There are about 14 or 15 kinds of choices that if you don't get to make these, you haven't been able to lead your life. These are the fundamental choices. And they can justify the liberty to do those. The goodness of protecting that liberty can protect even quite wrongful modes of making those choices. Sandra Day O'Connor on abortion, she got to write her opinions. It's really, really wrong. You're killing somebody. And yet it's more wrong of the state to take that choice from a woman than it's wrong for her to make it the wrong way. So that it's more important, even for quite wrongful behaviors, they not be prohibited by the state if it's a matter of these fundamental choices. It's the same for parenting of children. You can do that quite wrongly. Speech, you could hurt people badly with speech. I think suicides by people who have young children who need them, they're all wrongful behaviors. And yet in this notion, the basic liberty choices that you have to be able to make to have a life that you in sense call your own. That's the second safeguard. In between are all the complex balances of things that are somewhat wrong, but nonetheless the importance of making a decision is of some importance as well. And there the complex balance comes out sometimes one way, sometimes in favor of the woman. Prostitution, drug addiction, and the like. I don't think those are fundamental choices. I don't think those are fundamental choices, but nonetheless, they are liberties of action for which the state has to show somehow that you're making a wrong enough choice that the good of requiting it by punishment outweighs the taking of the liberty to make the choice. I don't think that's true of addiction. Libertarian on drugs. Well, those are the two substantive rights to liberty. I don't think I should go into something that's not particular to those anyway, which is the force of those rights. I do deal with that at the end of the paper. I asked you to read the chapter. But it's not particular to liberty. It's true of all rights. Namely, some of us disagree with other deontologists like Kant, who made the famous quotation following centuries of it being repeated, that better all of humanity should perish than that someone's right to be violated. That's the stuff you put on courthouses. And the stuff that gets people to the barricade, that it really is popping up, right? I mean, it just cannot be the case that it's better that humanity perish than the right to be violated. Jeremy Wolver and I have debated this for quite some years. If you want our latest, it just came out. How absolute are moral absolutes? I've gotten Jeremy down to just two that are left. Namely, he says rape and torture, those are absolutes, right? Everything else more is right. You can do it with good enough consequences, everything else. So rights for me aren't absolute, and the ontology isn't either. The right to liberty won't be either. The force of the rights for liberty will not differ from the force of other rights. I got other items on why sometimes it gets calculate consequences, but that's probably enough for the day. Thank you very much.